Okay, so we're going to make a start on the second arbitration. The second hearing involves a dispute over a coal cargo. And members of the audience, you should now please have a look at the other statement of facts. It's the one involving a ship called Interstellar. From the title at the top, you'll see that the arbitration is taking place this time under the CMAC rules of 2021. So what are the facts? The claimant is the carrier and the respondent is the receiver of the cargo. From the statement of facts, you'll note that there was a bill of lading contract for coal to be carried from Cortina to Pineland, and the bill of lading incorporated a charter, including the arbitration clause. So, what went wrong in this case? The answer is quite a lot went wrong. There were problems with import licenses and customs clearances, resulting in long delays and losses and off-hire. The vessel deviated to Alexandria in Attica, so that there are a lot of fictional countries in this statement of facts. The carrier now wants to discharge the cargo in Attica, but the receiver wants the vessel to return to Pineland to discharge there. Applications for declarations, injunctions, and damages are flying through the air, and you'll hear more shortly. For this second hearing, we're privileged to be joined by prominent arbitrators and very talented practitioners. The tribunal is chaired by Mr. Andrew Shepherd, an independent arbitrator. The co-arbitrators are Ms. Caroline Thomas of Hugill and Ip and Mr. Patrick Chan of Skuld. The claimants on this side are represented by Mr. C.J. Tang and Ms. Sherry of Tang & Co. in association with Helmsman LLC. And on the other side, the respondents are represented by Ms. Cheryl Yu and Ms. Anya Cheng of Reed Smith and Reed Smith Richards Butler. So with that, can I turn it over to the tribunal and parties?
Mr. Tang, are you ready to proceed?
Yes, I am.
Sorry, I have to remind everyone that please, it's tricky, but you have to hold the microphone quite close.
Try again, Mr. Hello?
You have to turn on the microphone and hold it quite close. Something I got wrong earlier.
Mr. Tang, try again. Are you ready to proceed?
Yes, I am. Good afternoon, Madam Arbitrator and Sir Arbitrators. Appearing with me this afternoon is my colleague, Ms. Sherry Ng. The respondents' counsels are Ms. Cheryl Yu and Ms. Anja Cheng. For the purpose of today's hearing, the parties have agreed to focus on issues relating only to the declaratory relief that is sought by the claimant, which is really to permit the discharge of cargo in Alexandria Port, as well as the injunctive relief sought by the respondent, which is to procure the return of the vessel to Pineland Port with the cargo carried on board under the bill of lading. The reason why we have decided to focus on just these two reliefs is because there is a pressing urgency for these issues to be dealt with liability to be determined later. We have said, I presume that the skeleton submissions have been read by the tribunal, and the facts are familiar to the tribunal and that we do not need to repeat them.
That's correct.
Given the short amount of time that we have, we propose to go straight into the application for the declaratory relief as well as the injunctive relief. Now, one of the things that we've said in our skeleton submissions is that the reliefs that are sought by both the claimant and the respondent are binary in nature. Now, if the tribunal were to grant the declaratory relief that is sought by the claimant for the discharge of the cargo in Pineland Port, then the mandatory injunction that is sought by the respondent must fail. Likewise, if the tribunal were to order that vessel returns to Pineland Port, then the claimant's request for declaratory relief to discharge the cargo at Alexandria Port must fail. Okay. We ought to clarify one further point. There is, in fact, a third possibility. That third possibility is if the tribunal finds that no declaratory relief should be granted to the claimant to discharge the cargo, it does not follow that a mandatory injunction should be granted to the respondent. What the tribunal can do is not to grant either the declaratory relief or the injunctive relief to the claimant or respondent. But that, we submit, is quite an undesirable outcome because the cargo on the vessel would be left to rot, for lack of a better term. So the tribunal will have to decide today whether it should grant that declaratory relief or the injunctive relief that is sought by the respondent. Now, we say in any event that the tribunal should not grant the mandatory injunction for the vessel to return to Pineland Port because it is not currently known whether the vessel is in a fit or seaworthy state to undertake that further voyage from Alexandria Port to Pineland Port. The vessel is in a condition where she is known to have extensive fouling, and it is also known that she will require extensive repairs. That is undisputed. Now, that alone should militate against the grant of any mandatory injunction for the vessel to return to Pineland Port. And we will elaborate more on the points later. But in deciding whether to grant the declaratory relief to the claimant or injunctive relief to the respondent, I think the tribunal's paramount consideration is what should be done to best preserve the interests of both parties pending the resolution of the substantive dispute between them. And once that point is considered, it will be readily apparent that the declaratory relief for the discharge of the cargo in the port of Alexandria should be granted. Now, the test for the declaratory relief is set out in the skeleton submissions. It is set out in the case of Deutsche Bank, London against Commune di Basto. And I just want to go very quickly into the principles for the grant of declaratory relief. The first point there is the touchstone is utility. There must serve a purpose for the declaratory relief. The second point is that the prime purpose of any declaratory relief is to do justice in a particular case. Justice includes justice not only to the claimant, but also to the defendant. And the third point that the tribunal should consider is whether the grant of declaratory relief is the most effective way of resolving the issues that have been raised. In answering that question, the tribunal will need to consider what other options are available for the resolution of that issue. Now, I now turn to the test for an injunction, which is quite distinct from that of the test of a declaratory relief. And we all know the well-established principles in American Synamid and Ethicon, which is the test for the grant of an injunction. The first issue, of course, is that there must be a serious question to be tried. In other words, the claim, in this case, of the respondent must not be frivolous or vexatious. The damages would be, the tribunal would have to consider whether damages would be an adequate remedy in deciding whether the injunction, the mandatory injunction should be granted. And the third point is the balance of convenience point. Now, while there is a distinction in the test between that of an injunction, a mandatory injunction, and that of a declaratory relief, there are in fact similar considerations to be applied in both of these tests. And I will go through the commonalities. One of which is, of course, what I've mentioned earlier about the declaratory relief, where justice is paramount. The requirement for justice to be done by the tribunal will play out in the test for the balance of convenience in the injunctive relief application. So that's where there is an overlap in the consideration which the tribunal will have to consider. Now, the second thing that I want to mention about is that the mandatory injunctions, by their very nature, are more oppressive than prohibitory injunctions. The hurdle for obtaining a mandatory injunction, is very much higher than a prohibitory injunction. The courts, and we would urge or request the tribunal to consider this, that tribunals should be slow to grant a mandatory injunction because it amounts to specific performance. It requires the owners to basically carry out what the respondent says is the duty under the bill of lading. And this is in the case of Shepherd Homes Limited and Sendam. I will just quote from page 351 of that authority, which is in the supplemental bundle of authorities.
Mr. Tang, can I just stop you? Sorry. Can I just stop you there? This was put in rather late, this authority, and I would like to invite the respondents to say see if they have any objection to it being made.
Yeah. We just know that the claimant just put in some new additional authorities, which were submitted to tribunal just before the hearing. The respondent object to such late submission, and we invite tribunal do not attach any weight to those additional authorities.
I'll hear what you've got to say on the matter, and the tribunal will make a determination later. Please continue.
So the first point to be made, of course, is the authority relates to that of an injunction, which is an issue that was known to both parties. The issue here is whether it's the case of it only relates to the issue of a mandatory injunction, the burden of proving a mandatory injunction. So we, strictly speaking, do not need to rely on this authority. The authority is meant to illustrate to the tribunal why a mandatory injunction would attract a higher threshold than that of a prohibitory injunction. And that's the only thing that we wanted to illustrate. And certainly the introduction of authorities at late stage is not something that we generally consider either admissible or not admissible. The introduction of authorities is meant to facilitate the tribunal's fair consideration of the issues at hand. So going back to the submissions, now in deciding whether to grant a mandatory injunction, the tribunal will also have to consider what's the level of damage that will be caused to the respondent if the injunction is not granted. What happens in terms of the detriment that it will inflict on the claimant or the respondent, and the benefit that it might otherwise confer on the respondent if the mandatory injunction were to be granted. So these are the things that have to be considered. And I propose to to address the first issue, which is the issue of whether there is a serious issue to be tried. And this test under the American Sinamid is really that the respondent's claim should not be frivolous or vexatious if they wanted a mandatory injunction. But on the facts of this case, it does not appear that there are any good grounds on which the respondent can say that there is a serious issue to be tried. Now, the respondent has raised a few issues on this. One is the deviation of the vessel. They've also briefly talked about in their skeleton submissions the issue of whether we were entitled to rely on the clause so near thereto as she may safely get. And the point about deviation here is that deviation is in fact justified by the owners. The owners were justified in taking the vessel from Pineland Port to Alexandria Port. It is incorrect for the respondent in their skeleton submissions to say that there is no contractual term that entitles the claimant to deviate from the contractual discharge port. If we look at Article 4 of the Hague Rules, Article 4 of the Hague Rules do actually permit deviation, and if necessary.
But we say that.
Sorry.
We're familiar with that.
Right. And there are circumstances under which you can deviate, and one of which is deviation for saving of life at sea or any other reasonable deviation. Now, the question here is whether there was a deviation for the saving of life, or two, whether there was any other reasonable deviation. And we say that on both counts, they are satisfied. The first point here is that saving of life is not the saving of mortal life. If we look at Views of Lading, the commentary in Views of Lading, 3rd edition, which is in the Supplemental Authorities, tab 2. The saving of life at sea at paragraph 11.280, the commentators say that this approach, if it just concerns mortal danger, the approach would be unduly restrictive if applied when coming to the rescue of somebody seriously ill or injured. Now, our submission is that the saving of life at sea can include health, physical health, or mental health. It doesn't relate just to mortal danger. And here in the statement of facts, it's extremely clear. The crew were suffering from chronic stress. They had been at sea for more than 6 months. Anyone who has been on board a ship and has been on board a ship for more than 6 months will know that chronic stress is a real issue. The owners were fully entitled to deviate in circumstances where there were no prospects of being able to berth at Pineland Port, to go to the next nearest port, which is at Alexandria Port, for the purpose of changing crew. The second point here is, even if the tribunal is not with us on the issue of the saving of life at sea, we say that there was a reasonable deviation in circumstances where the vessel and her crew had already been left stranded at Pineland Port, and the cargo has already become dangerous to the vessel. There is a pressing need for the cargo to be discharged from the vessel without any further delay, and there was no prospect of berthing at Pineland Port. the only other alternative is to deviate the vessel, go to Alexandria port and discharge the cargo there. Now, the next point that I wish to address is the issue of contractual entitlement to discharge at a port other than Pineland Port. The respondent has raised the issue about nomination of ports, and once there has been a nomination of a port, it amounts to an election, and therefore it becomes irrevocable. Now, that is only correct to a certain extent.
Are you still talking about the test of there being a serious question? Is that where we start?
Yes, that's where we stand.
Could we perhaps focus on the adequacy of damages and the balance of convenience? And also,
Sure.
I mean, there are two things which, as you say, are binary. So on the one hand, you have the declaration, and on the other hand, you have the mandatory injunction. You are now on the test for a mandatory injunction.
Yeah.
Which is in fact what the respondent's asking for, but you're saying they're quite similar. Is that why you're accusing?
I would say the test is different, but the considerations
Are similar.
in the context of a declaratory relief where the requirement is for justice to be done. Now, those considerations that apply to justice will also apply to the balance of convenience considerations in the context of an injunction.
Okay,
Yeah, so I will address them together.
okay, great, thank you.
Now, I will move on onto the issue of the adequacy of damages. And that I think can be addressed quite quickly, because if we look at paragraph 33 of the respondent's skeleton submissions, now the respondent merely asserts that damages are an adequate remedy, but they don't really explain why. And I can take the tribunal to paragraph 33 of those submissions, where they have said, per contra, if she does not go to Pineland Port but eventually discharges the cargo and even worse, sells it, there will assuredly be a very large claim by the respondent with untested evidence for which there is no relevant security. And they simply say damages are not an adequate remedy. Now, I would like to flip it around the other way to say their suggestion that there will be a very large claim is an implicit admission that damages are in fact an adequate remedy, and that specific performance of the vessel to go to Pineland Port is certainly not required, because they have admitted that damages are in fact, it only relates to a large claim, and that damages will therefore be an adequate remedy. And certainly one of the things that we will raise in this arbitration is that there is a limitation of liability under the Hague-Bisbee rules. Now, I will now go on to the issue of the balance of convenience. Now, where does the balance of convenience lie? What is said in the statement of facts is that it might be possible to discharge the cargo in Pineland ports between Feb and April 2023. Now, what the respondents have not been able to demonstrate to this tribunal today is that that state of affairs continue to exist even now. And that's the real issue. The receivers no longer have any import licenses to discharge cargo at Pineland Port. They say that if the vessel is brought back to Pineland Port, then they will be, if there is a willingness and ableness to bring the vessel back to Pineland Port, then they will be able to apply for import licenses. In other words, they don't have it. They don't have the requisite import licenses for the cargo to be discharged at Pineland Port. Now, this goes towards the issue of what I mentioned earlier. What is the utility of the vessel going back to Pineland Port? Do we send the vessel back to Pineland Port only for the vessel to remain at anchorage and not for the cargo to be discharged? That will cause further damage to the vessel. Now, the other point that I wanted to address was that the bill of lading actually provides for an alternative mode of performance as a matter of contractual right. It doesn't require the vessel to discharge the cargo at the port of Thailand. It allows the cargo to be discharged or so near thereto as the port of discharge in Thailand port, which could be in any other place, any other nearest feasible port or place to the nominated port or place, which is reasonably viewed in the light of the interests of both parties. The convenience of the consignees is not paramount. And I've cited the commentary on voyage charters, which is in tab A of the bundle of authorities. Now, we say that the nearest port or place should now be Alexandria, given the existing condition of the vessel. We've said that the vessel is in a poor condition, following the prolonged storage of the cargo in the holds, and the inability or the impossibility of discharging cargo in any of the Pineland ports. And the last thing perhaps to say is that we would like to preserve the possessory yen that has been granted by the courts of Etika in respect of the cargo. It would only serve the interests of both parties to have the cargo discharged at Etika port to ensure that there is no further deterioration of the cargo, and that there will be no danger to the vessel if she were to undertake a further voyage to Thailand.
Mr. Tang, I must draw to your attention that you're fast running out of time.
I will conclude my submissions here. Yes.
Thank you very much indeed. Monsieur?
Can I clarify first whether Sherry will make any submission? Oh, okay. So the claimant will not address any of the other claims for damages. I think both parties agree that it will briefly address those, but you will not make any submission on those claims.
No, the claims for damages, we propose to leave it for the next hearing. We will only address the interlocutory.
Yeah, understood, but I think we agree that we will both parties briefly mention about it, but never mind. Okay. So shall I proceed?
Please proceed.
Yeah. Good afternoon, Mr. Chairman and members of the tribunal. I appear with my co-counsel, Mr. Anya Chan, on behalf of respondent receiver. We have put a relatively detailed written submissions, and in interest of time, will not repeat everything covered in our written submissions. And the full set of facts has already been kindly summarized by our moderator, but I wish to highlight some facts which I would invite tribunal to pay special attention to. First, it is undisputed by claimant that upon the vessel arrival at Thailand port on 2nd August 2002, the delay in cargo discharge was caused by the Thailand Cortina trade war. Later, on 2nd February 2023, without permission from the respondent, the claimant caused the vessel to deviate to Alexandria, Attica. The claimant alleged that such a deviation was only for a crew change, but contrary to the claimant's state intention before the deviation, the vessel didn't return to pilot, but instead, the claimant applied to the Attica court for an order to sell the cargo by judicial auction. Most importantly, it is known that other vessels carrying the same type of cargo of the same origin, subject to the same type of expired import license, were all allowed to berth and discharge in the normal way at other pilot ports near the nominated discharging port since February, around the same time as when the vessel deviated to Attica. As of now, the vessel remains in Attica, carrying the cargo belonging to the respondent receiver. So it is the respondent position that the tribunal should reject claimant's declaratory relief and grant mandatory injunction, ordering the vessel to return to Thailand port with the cargo on board. So I agree with my learned friend that the most pressing issue at this hearing is where the cargo should be discharged. Attica, where the vessel currently is, or the pilot port, the nominated discharging port and the build landing. Tribunal, if I may move on to the first issue to tackle, which is whether the vessel can be discharged in pilot if it is ordered to return to the port. The claimant seeks to argue that it's unlawful to discharge in pilot, but it hasn't put up any evidence in support of their position. To the contrary, discharge of the cargo at the nominated discharging port in pilot is not illegal under pilot law. It seems that claimant's position is that because the import license had expired, it's still impossible for the cargo to be discharged at nominated discharging port right now. It's upon this basis that the claimant currently seeks a declaration for the cargo to be discharged in Attica. The respondent submits that it's plainly untrue that the cargo cannot currently be discharged at the nominated discharging port. While the cargo import license has now expired, it is in fact irrelevant as to whether the cargo can be landed and discharged. The import license is used for customs purpose, which can take place after the cargo is discharged. Further, there has already been direct evidence contradicting the claimant's allegation that the vessel wouldn't be permitted to berth and discharge. We are not saying the cargo can be delivered. We are saying here the cargo can be discharged. So the key fact that we invite the tribunal to draw attention to is that other vessels carrying coal from Cortina had all ultimately berthed and discharged their cargoes at other ports in Thailand, which are nearby the nominated discharging port. And the cargo discharged from these vessels occurred without any issues from the local authorities or vessels themselves. So it is simply incredible for the claimant to allege that it's impossible or unlawful for the cargo to be discharged at Thailand port in the circumstances. If I may raise a procedural issue due to this being a mock arbitration, normally parties would have already filed witness statement or like expert evidence before the hearing, and so the tribunal can read evidence. The respondent position is that the current evidence is already sufficient for the tribunal to grant injunction at this hearing. But if the tribunal is not prepared to grant an injunction at this hearing, the respondent would like to seek permission from the tribunal for adducing additional evidence on the lack of illegality and pilot law, and also a factual witness statement to show that discharge would be allowed by local authorities if the vessel is ordered to return. Yes.
On that point,
Yeah.
what about what the claimant said about the state of the vessel, the serious fouling and the need for repairs? Is the vessel in fact in a state that it could make the voyage?
Reading from the written submissions of the claimant, it cannot be concluded. There's no sufficient evidence that the vessel is in a deteriorated state. It's just the cargo. They are just alleging the cargo is in a deteriorated state, and there's no solid or valid evidence to show that the vessel cannot make a voyage back to the Thailand port.
As regard, you're asking for a mandatory injunction. First.
Yes.
So the claimant has taken us through some authorities. So the claimant attached cargo charter parties, and the claimant also just raised but has not provided American cyanamide. Do you agree that these are the correct authorities?
I have no objection to the principles summarized by the authorities. I agree that the main task is that the adequacy of damages to respondent and the balance of convenience. So I will address those two the tasks in my later submissions.
Yes, if you could take us through that, and also the rules applicable to this arbitration also say something about interim measures.
Oh, Yes, okay, so, can I, before I move on to, discuss the injunction, task, I would like to, address the, declaratory relief sought by the, claimant first, if I may, tribunal, yeah. I would like to, briefly, address a point that, the claimant has never pleaded repudiatory breach on the part of respondent. And so we would like the tribunal to pay attention that the bill of lading hasn't been terminated. In other words, the claimant continues to be bound by its terms. So i.e. to burst to and discharge cargo at the nominated discharging port. And my co-counsel, if I have time, may address the no breach of duty issue in her submission later. But since the claimant didn't cover those in the oral submission, but we will see what time's left. Next, I would like to briefly address the issue of wrongful deviation. The respondent respectfully submits that claimants ordering the vessel to Alexandria Attica amounts to a wrongful deviation. First, there is no contractual term entitling the claimant to deviate from the contractual discharging port or sell the cargo elsewhere. Second, my learned friend has discussed Article 4 of Hague Rules and seek to justify the deviation. However, the real problem is that even assuming the claimant had no choice but to effect the declared purpose of a crew change, but the claimant is not entitled to keep the vessel there for a radically different purpose, namely to seek to enable themselves to discharge and sell the cargo in other places. This was clearly a deviation in strict sense. And further, the claimant seems to wish avail itself of the so near thereto provision. The respondent does not object to the principle summarized by my learned friend. They also cite that case, Down-Lesson case, which is in their list of authorities. When the key issue is, however, the test is whether the discharging at the primary destination was prevented for around reasonable time and was so long as to make it impossible in the context of charter as a whole. The respondent position is that the claimant is not entitled to rely on the alternative method of performance. On the facts of this case, discharging at the nominated discharging port after February is possible. And even if it is impossible, which is denied, the nearest feasible port is in Pilot, not Alexandria Attica. Therefore, the so near to provision can at most justify the claimant ordering the vessel to sail to the other ports in Pilot, but certainly not Attica. When there was an unjustifiable or unlawful deviation, a bill of lading holder is entitled to affirm the contract. In this case, the contract is affirmed by the respondent, and the claimant is still obligated to perform their obligations and the obligations to ship cargo back to its nominated discharging port. And the respondent also wants to submit that the claimant is not entitled to any lien over the cargo, and the claimant is not entitled to interfere with the respondent's proprietary interest in the cargo. There is no lien clause provided under the bill of lading or at common law would enable the claimant to deviate and to seek relief from the Attic court to sell the cargo. Despite of that, an order from Attic court has already been granted. The effect of that order remains that the claimant's other claims would be paid all of the proceeds realized through the sale. So the Attic court order and the sale are not intended to provide security for those claims in this arbitration, but for the satisfaction of their claims. The respondent rejects the validity of the Attica order on the grounds that there is a valid arbitration agreement between parties. The proper jurisdiction, as agreed between parties, as Hong Kong arbitration apply English law. So the respondent respectfully submits that the tribunal should not grant any declaratory relief as sought by claimant. And turning to the respondent's application for injunction, the respondent agrees the principle summarized by my learned friends. And the respondent submits that the damages are clearly not adequate remedy to the respondent in such a case. First, the coal cargo presently on board the vessel belongs to the respondent, who as lawful holders of bill of lading. Pending the resolution of respondent's appeal in the Attica court, the claimant may still at any time make an application to start sale process in the Attica. It's presently unclear when the Attica court will hear the respondent's appeal. The claimant seeks physically to deprive the respondent of its possessory right, and in effect to disrupt respondent's use of the coal, which we are instructed would be for steel production. And the respondent cannot readily buy in alternative supplies of Cortina coal, and the loss of production would doubtlessly be described by the claimant as too remote to be recoverable. This is to answer the claimant's counsel the question that what's the damage that the respondent would face. Further, if the vessel does not return to Parliament Port, but eventually discharge the cargo in Attica, or even worse, sells it, there will be a large claim faced by the respondent with untested evidence for which there is no relevant security. Therefore, damages are clearly not adequate remedy to the respondent in such a case. And my second point is that the balance of convenience is preponderant and plain. As my learned friend has already summarized the test, the tribunal will have to consider whether there is a disproportion between the detriment that the injunction would inflict on the claimant and the benefit that it would confer on the respondent. The respondent submits that there is no such disproportion. The tribunal would agree that if the respondent is right and the discharge is now possible, that the matter can be fairly disposed of. But on contrary, even if the cargo cannot be discharged at the Parliament Port, the claimant's claims have in any event be secured by the cargo on board the vessel for their alleged claims. And the claimant still have to prove their case beyond serious controversy. And in the view of respondent, the claimant does not have valid claims against the respondent. In order to give more comfort, we have already opted instruction from our client to provide an undertaking in damages such that the respondent shall abide by any order the tribunal may make as to damages recoverable by the claimant as a result of their compliance with the mandatory injunction. So there is no such disproportion. And the sensible course would be for the claimant to agree to perform its obligation under the bill of lading. The sooner the vessel gets back to Parliament Port, the better for all parties. The tribunal are therefore requested to grant a mandatory injunction for the vessel to the Parliament Port on such terms that they think appropriate to protect all the legitimate interests. That concludes my submissions.
Hi,
Yeah,
I've got
yes,
a quick question.
yes.
Your submission said that on deviation point, circling back, you said that if the original discharge port is, say, impossible to discharge, you said the next discharge port should be another port in Parliament.
Yeah.
But as I have known from the facts, the trade war is the alleged trade war is between the countries. So in the situation that if the other ports are without, what is your position if all the other ports in Thailand has the same position that it cannot be discharged?
My position, my submission was that, there are very clear evidence to show that after February, the cargoes can be discharged in other pilot ports. And all those ports are near, in geography, near to the nominated discharging port. And actually, as I said, we plan to introduce witness statement to show that even for the nominated discharging port, it's possible to discharge now. So that's why we request the tribunal to order a mandatory injunction to order the vessel to return to the nominated discharging port for the cargo to be discharged there. And the key issue is that the import license is not relevant, because without such, even if the import license is expired, the cargo can still be discharged. It's just the cargo cannot be delivered. So nothing prevent the vessel to discharge cargo currently. I'm not saying before February, but after February, the cargo can be discharged.
Thanks, mate.
Thank you.
Thank you, madam.
Thank you.
I will start off by addressing perhaps an inconsistency in the respondent's submissions. Now, the respondent has said that it has said two things. One, that sure, they do not have the export license, the import license to enable the cargo to be delivered to the consignees. They can, however, discharge the cargo. Now, the question then is, what is the purpose of having the cargo discharged in Korea, in island ports, but not delivered to the consignee? Now, in making the argument that damages are not an adequate remedy, the tribunal would have heard from the respondent's counsel about how the non-delivery would lead to loss of production of steel and what have you. Now, the problem here is the cargo could not even be delivered in the first place. So even if the cargo were to be brought back to the port of Thailand, it will never be delivered to the consignees. And the loss will still result to the consignees. It's not the case that they will be able to use the cargo for their purpose. It's clear here in this case that it's not a case where damages are not an adequate remedy.
Mr. Tang, I'm going to interrupt you there. You say that consignees will never receive this. I think you don't actually mean never. I think you mean it's unlikely to on the facts as we know them at the moment.
Correct. And the facts are what we rely on at this moment because there is a pressing urgency for us to deal with the cargo in the interim. How best to preserve the interests of both parties. And we say that the best way to preserve the interests of both parties is in fact for the cargo to be discharged, for the cargo to be sold by the courts of Etica, and if necessary, for the courts to put the sale proceeds perhaps into escrow for the benefit of both parties pending the determination of the claims.
Mr. Tang, you were talking about what the court could do and perhaps pay money into escrow. Would the claimant be willing to consent to an escrow arrangement in Alexandria?
Certainly, this is what the respondent have agreed to do is to provide an undertaking, right? But what would be more effective in this instance is in fact for the claimant to provide an undertaking to this tribunal that any proceeds from the sale of the cargo in the Etica port will be put up in escrow pending the resolution of the dispute. And for these proceeds to be distributed based on any award that is subsequently made by the tribunal.
I have a question about the declaration. You took us to the test in the Deutsche Bank case and also said that utility is important. Now, given the pending court case, what is the utility of a declaration by this tribunal? And also, what declaration exactly are you asking us to make? What would it read were we to make it?
Sure. The declaration, the relief that is being sought by the claimant today is in respect of the discharge of the cargo from the vessel, and it's limited to that. It's about the discharge of the cargo to ensure that the cargo is preserved and to ensure that the vessel's condition is likewise preserved. The vessel, the cargo, due to prolonged storage, has become a danger to the vessel, and that's why the cargo needs to be discharged. What is sought in the ethical court is for the preservation or the claimant's exercise of a possessory lien. That's a matter of right. And if we look at Article 23 of the CMAC rules, now in terms of the preservation of property rights, it does say that where a party applies for the preservation of maritime claims or preservation of other properties before the commencement of arbitral proceedings, so on and so forth, it shall submit the application directly to the competent maritime court or other competent court at the place where the property reserve is located. So that really relates to the exercise of a possessory lien that the claimant is entitled to have. And of course, the other aspect, the relief that is being sought for in the ethical court is the judicial auction and sale, which is really the preservation of proceeds pending the determination of this dispute. What my learned friend has not addressed in her submissions is about the vessel condition. Her primary concern, the respondent's primary concern, is largely about the cargo, getting the cargo back into Hainan port. But what my learned friend has not addressed is the issue of the vessel's condition, which is something that the tribunal should take into consideration in determining whether a mandatory injunction should be granted in circumstances where the vessel is, it is not known what the vessel's condition might be.
Mr. Tang, if it's not known what the condition of the vessel might be, how can we possibly take that into account?
What I should clarify is what we do know is that the vessel's condition is foul. What we do know is that the vessel's condition requires extensive repairs. Now, the issue is, can she actually undertake a voyage between Hainan, Alexandria to Hainan? The answer is no, unless we are certain that the vessel is actually in a seaworthy condition. Without knowing that the vessel is in a seaworthy condition, to risk going to Hainan port at this stage is to put the vessel in purview.
I would actually be interested in hearing from the respondent. So the claimant has just proposed to give an undertaking, as I understand it, to pay the proceeds of sale of cargo into port.
First, the response does not agree with the claimant to say that in both scenarios that the same will be the same if the cargo is discharged at Attica or going back, or the vessel is ordered to going back to Hainan port. If the vessel is ordered back to the Hainan port, the cargo can be discharged, as we have already mentioned, and then the respondent is likely to get a renewed import license. So there is a likelihood that, or in the near future, that respondent can receive those cargo. And as I mentioned, I've been instructed that those cargo are for steel in production as important for the client's business. And our client cannot secure alternative supplies. So, but if the cargo is discharged in Attica, our clients will be deprived of any proprietary interest in the cargo. And that means our client will lose the cargo. So that's different. It's not as the claimant alleged that. That's completely different scenario for our client. And it appears that the claimant suggests that the cargo on board the vessel is dangerous. But it's the respondent position that the cargo is not a dangerous cargo. It's a Cortina coal. And the claimant has never put up any evidence to show that the cargo is a dangerous cargo or in their claim submissions. And the claimant knew the cargo was the Cortina coal, and it knew that the destination is the Thailand. And that was all the claimant readily need to know about cargo in order to carry it safely. And by accepting to receive hire, the claimant has accepted risk of carrying this coal and carrying this coal. And it appears that the claimant only mentioned that the coal has alleged coercive quality in their claim submissions, and any alleged prolonged storage was caused by claimants. It was caused by claimant's own wrongful deviation, for which the respondent shouldn't be liable. And it's unclear that, and no evidence to show that the vessel is in danger.
Miss Yu, I'm going to interrupt.
Yes, sure.
You're making assertions which we as a tribunal will try and address in due course about the condition of the coal. And you are asserting on the one hand that it being a coal cargo, it can't deteriorate. And if it does deteriorate, it just deteriorates on the voyage from Heinlein to Attica. Well, I put it to you that the tribunal might depart from you on that in due course, because whilst there is always the scope for inherent vice in many cargoes, be it rice or nickel or whatever it might be, it's not contemplated that you'll sit waiting to get an import license and permission to enter port for many months, which is what happened here. So I would urge you to veer off that particular point at the moment. We won't find it particularly helpful for you to continue.
Oh yes, thank you, Mr. Chairman. And actually, but for real situation, for the next hearing, parties can submit evidence to show the cargo condition. So, but this for mock arbitration, we are not unable to show that.
Looking at the clock, unless there's anything further from the parties, Ms. Yu, you made your question.
No from the respondent.
Any further to put to the tribunal?
Not much further. Thank you.
You want to continue?
I would only have made one more
Please
point.
do, yeah.
About my learned friend wanting to use other evidence to allow the discharge of the cargo in Hainan Port. The point here is that this is an urgent application to the tribunal where decisions have to be made now rather than later. Had the respondent wanted to use any other additional evidence, it should have done so at this hearing and not at any later stage.
The additional evidence will be at the substantive hearing, which we will explain further. But there's no impediment to putting in evidence at that hearing and to make reference to it in advance. Just isn't present before us at the moment. Anything else, Mr. Tate?
That would be all.
Right. at this stage, for people sitting out there, we'll tell you what would be going on. We would have a recess and we go away and we discuss it between each other. And then we come back and I, as chairman, will now pass it over to Ms. Thomas, who's going to give our views on the primary application that's left. Then I'm going to pass to my colleague on my right, who's then going to suggest areas of expert evidence and evidence that might be required. And then I will add my comments as to what we would be looking for in the substantive hearing. And we're going to treat this as an interim arbitration award and nothing more than that on a very discrete point. There's reference has been made to all sorts of things that there is no evidence, but evidence could be obtained normally in due course. I've some time ago was privy to an interim arbitration which took place by telephone. This is before we all had computers to look at each other. It was done that quickly. So with that background in mind, treat the tribunal as having left, having come back, everybody sat down, and now I'll pass you over to Mr. Thomas.
We were asked to do two things. First of all, to deal with the claimant's request for a declaration, and secondly, with the respondent's request for a mandatory injunction. And the question really is, where will the cargo be going? And the tribunal dismisses the respondent's application for a mandatory injunction and grants the claimant's request for a declaration, but with the proviso that if the cargo be sold, the claimant has given and will give now a written undertaking that the proceeds are paid into escrow at the court.
In relation to the other issues raised in the submissions, although we understand that for the sake of time, the issue regarding the damage of the cargo and the damage of the vessel was not explored deeply. But for the interest of this hearing, this mock arbitration, as a demonstration, based on the evidence and state of facts available right now, the parties actually write that in an interim basis, the purpose of this hearing will be focusing on the injunction, because there won't be enough expert evidence at this stage to deal with the issue regarding damage to the cargo and the damage to the vessel. Therefore, on the interim hearing, it would not be appropriate at this stage to make an award or declaration as to which party is responsible for these issues. But to help in the substantive hearing, the tribunal will order that for the purpose of dealing with the issue of the damage to the cargo, the parties are to provide a joint expert report in relation to the condition of the cargo, and the expert will be appointed by the tribunal, and both sides can provide their instructions and evidence in support of to help the tribunal appointed expert to prepare the report. In relation to the damage to the vessel, the tribunal also direct that both parties provide the expert evidence as to whether the cargo will be the cargo actually caused the damage to the vessel for one point, whether it's corrosive nature. And then the second point is the hull fouling, whether the reason of the hull fouling was due to a prolonged stay, as in whether it was done in Attica or in Hainan. And to circle back a bit on the previous, the cargo damage point, the court appointed arbitrator, the expert, will focus on basically the issue as to whether the cargo itself was corrosive in nature, whether it causes, they will answer the question as to whether the cargo actually causes danger to the vessel and whether it causes damage to the cargo holds. And that's it from my end.
Thank you, Mr. Chan. things that the tribunal will be looking to the parties to provide at the next hearing. We look forward to seeing you there. Certain presentational issues to start with. It would have been helpful to have a dramatist persona. It would also have been helpful to have a schedule of events and facts set out in date order. And Mr. Tang, if you're going to refer to an authority such as the American Sign Language, it would have been helpful to have had it. But these things are done in a hurry when you've got an interim arbitration of this expedition. As to issues that the tribunal will expect to be explored in your submissions, if this matter is not resolved amicably outside hearing, is in relation to maritime liens. Some of the assertions made in the respondents' submissions were slightly awry. There are maritime liens under common law, and they dovetail to a large degree with possessory liens. And of course, it was also raised in frustration. So have a look at those issues together. Bearing in mind the difficulties that you're facing, you've got an appeal pending going to the court in Attica. The question of the confidentiality of the award that we're going to hand down pursuant to Article 43 of the CMAC rules. We can't waive the confidentiality as a tribunal. Only the parties can do that by agreement if they so choose. As to how the courts will deal with it, it's a matter entirely for the courts. But it's an important issue, we would imagine, for the appeal. And bearing in mind the terms of the interim award we've made today, final award in relation to the discharge injunction, but interim in relation to anything else, the question is, you may not even wish to appeal. But that's entirely a matter that you will have to consider yourselves. Transshipment. We've heard nothing about that. We will have to explore that. It's an issue that goes to damages as to why transshipment hasn't been considered, if what you say is true, Miss Yu, and the costs, etc. We will also be looking at coal prices, both in Pineland and in Attica, in terms of damages that might be claimed. And you say that it's impossible to source further coal of this nature. Again, you'll be having to provide evidence of that. Not necessarily in order, but in the order I've written them down here, so forgive me, it's a bit haphazard. Costs. There's been a very significant throwing away of costs today, in that you've refined the issues at the last minute. Of course, the cost of the tribunal will not reflect that. So you might wish to take that into account, and an interim bill will be coming from the tribunal in relation to the award. There are various other parties who've fallen by the way. The primary case of yourself under the Charter Party against your charterers, we would expect that to be explained when you next appear before us. And also the issue with receivers. Demurrage and lay time has been mentioned in passing. We will expect and hope that that issue can be agreed, but if not, it's certainly a matter for the tribunal. I would remind the respondents that once on demurrage, always on demurrage. So your submissions might be revisited bearing that in mind. Crew statements, stress. Now we would expect evidence to be provided from the crew, and in relation to crewing, why was it not considered to put a replacement crew on board the vessel in Pine? Was this not possible? Perhaps you will be getting factual statements for us to consider in relation to that. Also, Miss Yu, you've mentioned Pineland ports. We'll want to know the conditions of the other ports, the terms of congestion, whether berthing was available, what would be the position with licenses, etc., deploy your argument that there were alternative ports in that jurisdiction. And similarly, you've diverted to Attica. We'll need to know that everything is in order in Attica for discharge over and beyond whatever the courts may say about the and the courts administer the sale of the vessel, a sale of the cargo. The customs of the port. At the moment, it's a bit of a grey area as to why you couldn't get in. So we would hope that a statement from the harbour master might be available to explain matters. And if as is normally the case, the harbour master would be reluctant to make such statements for reasons that are clear, perhaps surveyors using that port could give the statement instead, together with details of waiting times and why certain vessels got in without the license and this particular vessel didn't. It may be something to do with the flag of the vessel. It may be something to do with the origins of the cargo. We don't know, but we will want to know, and it's up to you to provide us with that evidence. So port practices in general. Also, the Baltic Exchange gives notices of problems like this, and I'd like to know what the Baltic Exchange will have published in relation to this port issue. There will be other matters that will be germane. We'll be needing to know the costs of the voyage from Pineland, including bunkers, etc. That will be relevant to your claim for damages. Allegations have been made about the earnings of the vessel, so you'll be presumably putting in or seeking to put in expert evidence from a shipbroker to this effect, and presumably you'll be seeking to put in evidence from a shipbroker countering whatever Mr. Yu might put in on that. And also in passing today, limitation under the Hague Visby rules, as we mentioned, will be expecting full submissions upon that. And unless I can be of any further assistance to the parties at this stage, Miss Thomas? Miss Thomas.
I just wanted to commend the parties for a really interesting fact pattern and actually really good submissions. Unfortunately, we couldn't go all the way through, but one thing we did notice, especially Patrick from the club's perspective, is this actually happens. And so, for example, Indonesia is one where they often have suddenly export restrictions. I remember this happening twice. And you can have vessels hanging around for an awfully long time, and then you get confronted with really, really complicated issues, including frustration, force majeure. And here you had a very interesting thing, because of course you had a charter party. There could be different kinds of charter parties. So Patrick has obviously seen several of these, and that you have on the one hand you have the charterer, but here you also have the respondent. So.
Yes, I'm pretty sure the similar facts was based on both sides' past experience and or real life cases. So there's a really good job that the preparation of the submissions and the statements. Diverging on from what Karan said, usually in this situation and for the interest of the case, in this case you have the receivers and the ship owners. But in real life, the chargers will also be very much involved in the case. For example, the claim on the hull fouling, the division, or just the very issue of the hire, payment of the hire, because in this case, the charters did not pay the hire after a few months. So there will be a claim for owners to the charters. If it was a rising market, for example, then loss of earnings from owners, and that will be quite relevant. And I think this scenario is based on in the early 2000s. In the Australian coal import situation to China. I mean, some of us in the room maybe have experience in doing it. So not a lot of those cases went to arbitration at the end, but it's a very good good practice today to actually have a mock arbitration on the scenario, which I think the parties did really well.
So, just one last point. Payment to escrow. You talked about that. It would be ideal, I think, well, it's subject to what the court says, because it's going to be a court sale of the cargo, is whether the court will administer that rather than put in escrow. If it goes into escrow between the two parties and they fall out, it can stay in escrow for some considerable time, and then applications have to be made to court. Another alternative might be for it to be put into the arbitrator's account, but they have to open the account, and whether CMAC doesn't seem to have a facility for it, doesn't have to say you can't do it, and we haven't searched whether CTAC can or not. So that's an issue to be considered. One other thing relates to what Mr. Chan was saying. It wouldn't be the tribunal appointing the single expert, it would be the parties, because otherwise we have to pay for it, which we won't do. So the parties would come up with a sole expert, and we would, if you couldn't agree one, we would decide who it's going to be, and the parties would have to agree that. The reason we suggested, this is basically for everybody else's benefit, a single joint expert in relation to coal, it keeps the cost down. And there is no point in having two experts looking at a piece of coal, coming up with a different conclusion. It will happen if you get single experts. So appoint sole experts when you can, and the courts are definitely in favour of that. When it comes to the vessel, that's not possible. So that's why Patrick made the other suggestion. But if I can just echo what Ms. Thomas said and Jan said, thank you very much. All the hard work has been done by these people. It's very easy for us to sit here and find fault with it, but we couldn't. They've done a great job, and we should thank them. Thank you very much.